A lawyer who represented victims of the Navy's worst peacetime disaster is under investigation over claims he's ripped off the clients he was fighting for. Court documents show the litigation earned Melbourne solicitor David Forster more than $10 million. But investigations have revealed serious discrepancies in his trust fund accounting and questionable billing practices. Forster maintains he's innocent, while his former firm is in receivership and he fights to retain his right to practice. James Bennett reports.
Most of the runs we run over voyages. One I said, "Don't be stupid." And he said, "No, go and look on the bridge." And I watched out the Admiral's Bridge, and all I saw was a stern of Voyager.
Barry Spalding was a sailor on HMAS Melbourne when it ploughed through HMAS Voyager during night exercises in 1964, killing 82 men. He wasn't injured, but the emotional scars ran deep. 3 decades after the tragedy, he was diagnosed with post-traumatic stress disorder.
And I was having a lot of bad dreams and nightmares, and sort of yelling out at night and waking up with cold sweats.
He says the aftermath of the collision destroyed his marriage, and Barry Spalding even tried to take his own life. Eventually, after a 7-year legal battle, his luck seemed to change for the better when he won a significant payout, but he never saw more than a fraction of it.
Finally got a settlement one day, which was $250,000, $200,000 for upkeep and ongoing medical expenses, and I received $29,000 out of all that.
A report filed in the Victorian Supreme Court last week shows most of the money went in legal fees.
The way these men have been treated has been totally inappropriate.
Barry Spalding's lawyer, David Forster, fought the Commonwealth for more than a decade, seeking compensation for sailors on board the Melbourne. But he's now fighting regulators. His former firm is in the hands of receivers, its assets frozen.
The claims that I have overcharged are false and unsubstantiated, that the errors which occurred in the accounting system were known to the Law Institute of Victoria.
Accounting firm Deloitte has examined 10 of the 89 Melbourne Voyager cases Forster's firm Hollow's lawyers worked on. The report found that in 9 cases, Forster's firm likely breached lawyers' trust accounting rules by charging more than the amount clients had agreed to. Only one of those 10 clients ended up with more than 10% of the money awarded to them. But David Forster maintains the cases were long and therefore expensive.
Since 1994, I have been complaining loud and clearly that it was a disgrace as to what was occurring with the costing of these processes. I feel very much for sailors that have had to go through litigation of up to 10 years and then have to fight all the issues that the Commonwealth sought to fight against them.
In March, in a decision to appoint receivers to David Forster's firm, Victorian Supreme Court Justice Karen Emerton said she accepted that the Melbourne Voyager litigation was long and difficult, and the defendant, Forster, undertook the long haul on behalf of his clients. But when he referred repeatedly to the large amounts of fees that had been written off, the clear implication was that it was of little consequence that he had taken monies to which he was not entitled. Much more was owed to him in any event. According to the Deloitte's report, there were 7 instances where Forster and his employees billed more than 24 hours in a day. In one example, a solicitor billed 66 hours in a day for a conference for 6 clients.
You can't multiply it. If you're doing one job for 4 people and it takes you 1 hour, you can't charge 4 hours for that work. You should charge each of those 4 clients a quarter of an hour's work.
In 3 cases, including Barry Spalding's, David Forster had the client sign more than one fee agreement.
Because the first one was like I think it was a standard one where he gets 25% of the award, no win, no claim. And apparently the other one, I never even read that because I was getting a bit more stressed out this time, and each time I had to go down to an interview with Forster, my daughter in Melbourne, Sandra used to come on with me to make sure everything was okay. Anyway, there was one trip she couldn't come with me, she was busy, and that's when he brought out this other form for me to sign.
You can't have both. You might have a separate agreement with your client to swap from one arrangement to another, but that's got to be transparent, that's got to be understood by the client, and it's got to be done in the interests of the client.
David Forster says the second agreement was needed because he was fighting the case in multiple jurisdictions and describes the recent report as an expensive waste of time.
The Deloitte's report, unfortunately, is an adversarial, selective document which is unfairly biased and improper. It hasn't been subject to scrutiny by anyone. It's taken over 8 months, and it's scandalous that after 8 months and spending upwards of $520,000, that there's no conclusions reached.
A complaint in 2007 from a former employee prompted an investigation of David Forster's trust accounts in early 2008. Investigators found numerous deficiencies. Justice Karen Emerton granted the Legal Services Board's request to appoint a receiver, saying the primary imperative was to ensure that the firm's clients and the public generally are protected. Except neither the board nor the receivers told the clients.
I think it would have been a good idea, yes. Would have been nice to know. I still haven't been told by anybody except you guys.
Not all of them have received the same information, and they should have, and they will.
In a normal receivership, calling a creditors' meeting is priority number one. But only one of the dozen or so clients contacted by the 7:30 report knew what was happening, or that they could complain about their bills.
I thought, well, OK, he's ripped me off and, yeah, there's nothing I can do about it.
At the end of the day, all I can say is that I will work for years for very little reward over 17 years, that it was a huge struggle, and throughout that process I've worked as hard as possible to obtain the best possible result in the circumstances.
In September, the Legal Services Board refused to renew David Forster's practicing certificate, but he's challenging that decision. Under the Legal Profession Act, he's entitled to remain a solicitor until the matter is settled. The receivership too is dragging on, prompting Justice Emerton to say it risks turning into another Voyager case itself. Barry Spalding has heard it all before.
And I thought, he's my lawyer, he's not going to cross me up, he's on my side, he's looking after my interests, and he wasn't at all.